Wow, wow, wow. This is sad. Yeah, so anyway, welcome to our medical negligence class. I was just trying to provide a recap of what we did. I think because of time, we will just continue. And after the class, I will share the lecture notes with you so that we can go over it. So then the last time, having discussed the the situation of multiple tortfeasors and how the court tries to determine uh, which of them should be held liable for the injury, and as to whether there has been a break in the chain of what causation. We also discussed contributory negligence and made, of course, before contributory negligence, we also talk about the doctrine of the loss of chance. That is where the patient is complaining that had the professional, healthcare professional or the facility provided intervention or done the needful, he or she will have had like a better chance in terms of recovery, in terms of favorable prognosis, and that he had been deprived that and should be compensated. Now, with respect to that, we noted that the courts, especially the English courts, are quite careful and would only entertain such a claim where the chance which the patient has lost is so significant. And then significant here, if you look at it initially, it had to be something more than 70-75%. But now, let's say anything more than 50% will have a favorable consideration by the court and say that you could probably maintain a claim against the healthcare professional or the facility that deprive you of the opportunity of such a recovery or getting a treatment as the case may be. Just aside, those who monitor the news, I think on my way from work today, I was listening to the BBC in the car, and I heard about this news, the Alzheimer, that disease, I think the mental health degeneration. There's a particular drug which is been helping some patients, but then in the UK, because of the state-funded healthcare, the NHS, such drugs will have to be paid for by the NHS, and the NHS, using their own study, are saying that the benefits which the patients, that is the Alzheimer patient actually get from that drug is actually minimal compared to the cost of its acquisition. In other words, they're saying that the drugs, the cost of it is so expensive that if you look at the benefit which brings to the patient, it's not that significant. And for that matter, they're considering taking it off the funded drugs. But then the company which also produces that drug has also come out with its own research to say that there are more benefits to the patient, of course. So whether their research is biased because of their marketing opportunity or advantage that they stand to gain, that is something that we are unable to determine now. But what is important is that where, for example, a patient will say that if this drug, for example, had been prescribed for me, my condition would not have actually degenerated or would not have escalated, and it would have significantly gone down or something like that. And especially we noted that when it comes to some serious diseases like cancer and some other things, it needs early diagnosis so that the management can start early and prevent it's becoming more aggravated or escalating. And then where there had been a negligence, like in terms of failure by the healthcare professional to make early detection, make early diagnosis, so as to raise the flag for the patient to be on a regular monitoring and so on. If there are some interventions which could have actually slowed down the degeneration of the condition, the patient will have been denied that. And that could be an example of a loss of chance claim which the patient may bring. Then we also talk about contributory negligence. We said that with respect to contributory negligence, where the court has actually made a determination as to whether a particular healthcare professional in a facility, for example, is to be held liable for the injury that the patient has complained of. The court would also look at the role which the patient played. Did the patient's own actions or inactions worsen the injury? Yes, there had been a breach, and the breach has actually caused injury. But then the seriousness, the severity of the injury, could it have been relatively less if the patient, for example, had done certain things or had not done certain things? So the court will look at that and make the determination. And that is a contributory negligence. And that principle has actually been elevated to statutory footing. It's not just a common law principle. It's a statutory basis. So in Ghana, for example, we have the Civil Liability Act of 1963 at 176, which also mirrors aspect of the English contributory negligence Act of 1945. Then we also came to discuss advanced and specific issues in duty of care. We look at the situation of emergency and then special situations. We look at the number of case law. We look at a situation of field medicine, and then when there's a disaster, how does the law actually calibrate the duty of care? And I think we also look at some evolving standards as far as the breach and standard of care is concerned. I want to believe we discussed all this, or they didn't go beyond that. Did you get here? Did we discuss this aspect at the last time? Okay, all right, thank you, Abiana. Yeah, so we will continue from here, complexities in breach and standard of care. Of course, we've already met this issue already, but we are just looking at it a bit more closely. And to start with, we have made the point that in a clinical or medical negligence case, having established that the healthcare professional, and for that matter, vicariously, the health facility owed the patient, the plaintiff or the claimant, duty of care. The plaintiff would not have been finished or discharged the burden imposed on him or her by law. He must go the next step to show that that duty of care was actually broken or breached, leading to whatever grievance that he has, for which reason he's come to the court. And question is, how do we make a determination as whether there has been a breach of the duty of care? We have noted already that you need to have a standard. We need to have like a benchmark, a marking scheme, as it were, just as how we grade your papers. So what was expected regarding this particular situation? Now let us measure what was expected with what actually happened. And then we'll be in a position to know whether there has been a breach of duty of care. So that is a standard of care. So what is the requisite standard of care in a situation like that? And then let us find out whether what was done or what was not done actually measured up to that standard of care. Already, we have noted the Bolam case. That's the Bolam against the FRIERN Hospital Management Committee, in which the position was propounded that the orthodox caution in negligence has been whether the clinician acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular act. And we have emphasized that by that approach, which Justice McKnight propounded in 1957 and subsequently endorsed by the House of Lords in Maynard and other cases, the point being made was that if a responsible body of healthcare professionals will say that they will have behaved in the same way that this particular defendant, healthcare professional or hospital behaved regarding the case we are talking about, then the court will say that the defendant is not liable of negligence, cannot be blamed for negligence. He can only be blamed for negligence where other responsible body of doctors will come and say that they wouldn't have handled it that way. So that is the Bolam, as we have seen. And remember the story, so we will not belabor the point. There was a EC, electroconvulsive therapy, and it was done without muscle relaxant, without anything using to restrain the patient. And eventually the patient jumped off the bed and sustained injuries, and for which reason he sued. So this was a jury trial, and the judge, in trying to direct the jury, asked them to consider whether what the particular doctor did was supported by like what other doctors would have done. And it doesn't, so long as some doctors who have done what he did, that suffice. So even if you have like a expert witness, as happened, some are saying that I will have done it, I will have restrained the patient. Others are saying I wouldn't have restrained the patient. Then the court says that so long as what this particular doctor did or this professional did is consistent with what a body of health professionals, even if they are in the minority, said they will have done, then we cannot blame this particular healthcare professional. Of course, that approach, as we have indicated, manifested excessive difference to the healthcare profession and a reflection of what we call the medical paternalism. But over time, as we have seen, a lot of suspicion was expressed regarding propriety of such approach. and cases, about 4 decades later, cases like Bolitho against the City Hackney Health Authority added another layer, rationality filter. So in Bolitho, a pediatric registrar failed to attend a corpulent child who later suffered hypoxic brain injury. And eventually, when the matter traveled up to the House of Lords, Lord Brown Wilkinson accepted that professional witnesses could justify non-intubation. Of course, some have said that they will not intubate the patient, others have said they will intubate. Yet insisted that the court must be satisfied that the body of opinion has a logical basis. In other words, in Bolitho, the court was trying to tell us that we don't have to simply say that because some health professionals, health experts have come to testify and say that, yes, what the particular defendant under the trial, the healthcare professional defendant facing the trial did, they will have also done that, or what they did is consistent with what some doctors will have done. That should not be an end to the work of the court. The court must not just take that at its face value. The court must subject the opinion to scrutiny, to analysis, to find out, based upon the various premises, the various explanations that they have given. Can it withstand logical scrutiny? Can the conclusions and opinions, is it borne out by various things that they have said? If the court realized that there was a logical deficit, then it did not matter that a body of healthcare professionals have said that they have done that. The court could easily ignore that and go on to make its own determination. So, Bolitho could be said to have preserved judicial control. So, expert evidence is necessary but not conclusive. And for lawyers in the class, maybe one tip I'm giving you is that when it comes to other areas of litigation, the principle is the same. Expert evidence, expert reports are important, but they are not conclusive. The position of the law now is that a court is not bound by expert evidence. However, where a court is rejecting expert evidence, the court must also have coherent logical basis. It's not just enough for the court to say that it is not persuaded by the expert report or testimony. Yes, it's not binding on you, but then the point is also that why are you rejecting it? You must have convincing explanation why you think that it's not safe to rely on that expert testimony or report. Otherwise, let's look at the situation where you have an expert. Let's say in a typical trial, you have expert, testimony, and during the cross-examination, no significant impeachment has been made as far as the credit or the competency of the expert is concerned, and the substance of the report of the expert has also not been discredited, has not seriously been rebutted. Then you come to write your judgment and you just simply say that you are not following that expert report. That will raise a question mark, because why are you rejecting it? You must have a reason. If you can show that, yes, maybe the expert has a questionable competence or his testimony is incoherent, and you can demonstrate that from what is on record, then you will be at liberty to ignore it and then proceed as you deem fit as an adjudicator. So let's keep that in mind. So in view of the shift from Bolam to Bolitho, some authors, including Michael Powers Harris and Lockhart Merams, in their very important work, Clinical Negligence, they call that shift responsible plus logical test. So responsible, that is Bolam plus Bolitho. So Bolam talk about responsible body of medical opinion. And then Bolitho said that subject that to logical scrutiny. But then when it also comes to consent cases, we witness a sharper move from professional to judicial standards, and the court wrestle more control from the healthcare professionals. So, for example, in Rogers against Whitaker, we had an ophthalmic surgeon who failed to warn a patient of 0.01, mind you, it's not 0.10, 0.01% risk of sympathetic ophthalmia in the good eye. In other words, there was 0.01% that such a condition could develop in an eye, which at the time looked relatively okay. This was an Australian case, and the High Court of Australia, so the High Court of Australia, let me remind you, it's not just a High Court, it's the Supreme Court of Australia. They call it their Supreme Court, the High Court. The High Court of Australia held that a risk is material if a reasonable person in the patient's position will be likely to attach significance to it, adding that expert testimony is a useful guide, but ultimately it is for the courts to adjudicate. In other words, in Rogers and Whitaker, the Australian High Court, for that matter, the Australian Supreme Court, was reminding us that when it comes to issues of disclosure and consent, it is not enough for medical experts or professional, healthcare professionals to say that, well, in situations like this, the risk is so insignificant, and for that matter, the patient need not to be told before the patient consent will be given. The court said that that was a wrong way to go about it, and what was actually needed was that we must have regard to the patient's circumstances, the patient's situation, before we can judge whether a particular risk is material or not in terms of the duty or the obligation to disclose it. In any case, depending upon the particular patient situation, okay? So let's say that if you have like a patient, let's say assuming you have a patient who is a driver or who is a pilot, and you have this 0.01% of this sympathetic ophthalmia in a good eye, when in those type of jobs, maybe like the eye test require 100% good eyesight. So where you don't make a disclosure to the patient for the patient to consent to whether particular procedure or not. This is what the courts are talking about, that in that case, you will not have had the condition of the patient having been factored into the equation in trying to make a determination as whether the risk was material and for that matter necessary for you to be disclosed. Yeah, there are a lot of other cases, and we know our own English case of Montgomery against like Nasher Health Board, which has brought the English medical law in line with the Australian position of the Rogers and Whittaker. And in the Montgomery case, as I recall from last semester, a consultant obstetrician failed to warn a diabetic mother of 9 to 10% shoulder dystocia, risk of vaginal delivery. That if you do the vaginal delivery, we had this percentage of risk of you having shoulder dystocia. The doctors who are here, can you explain the condition of shoulder dystocia for us? Or anybody, if you are not a doctor and then you have the practical experience. Oh, yes. Okay. Right. Thank you very much. Yeah. So in that case, as you remember, the court said that despite the fact that the raise was less than about 10%, it was still necessary for the patient to have been told so that the patient to decide whether she would like to do cesarean session or we run the risk of doing the vaginal delivery as actually happened. Well, maybe we need to move very fast, but just the point to notice also that now that we have technology, and technology is dynamic, as you can notice. Now we have a lot of things coming up, and especially AI technologies when it comes to medical diagnosis management reviews and all that. Powerful algorithms, which sometimes can even be a bit more accurate than what human analysis will do. So that is also presenting a challenge to how the law is. And this is an area of the law where technology and advances in medicine generally is always challenging because, as we know, scientific knowledge advances, they don't remain static. They're evolving. And that is why if you are also interested in this area of the law, you should be interested in also reading medical journals, especially, let's say you're a lawyer going to do medical negligence litigation. Know the particular type of problem that the case is about. Go and read extensively about it, and be on top of appreciation of the nuances, so that when you are doing cross-examination, you know clearly in your mind what you want to achieve and how you are proceeding. Don't just do this type of cases as if like you're doing like a normal land case or something like that. No, that is the wrong way to go about it. If you do that, the law will not develop, and you also not make the necessary impact. Yes. Yes, do please. Okay. Thank you very much. Yeah, so another thing we need to think of in terms of the standard of care, breach of care, is what we call guidelines and consensus statement. In other words, where we have clinical or practice guidelines, we have a consensus statement by either the healthcare professional association or the regulator. And if a physician or healthcare professional, for example, has actually acted in accordance with any of these guidelines in force, and still something goes wrong and the person is sued for medical malpractice, clinical negligence, will it be a sufficient defense for the healthcare professional to say that what I did, the procedure I used, is in accordance with the established guidelines, protocols, or consensus statement with respect to that particular condition? So that is what we are interested in. So what is the status of guidelines? Well, cause treat published protocols. For example, if you go to UK, they have various bodies, including the NICE, the National Institute of Clinical Excellence in England and Wales, and they have like the similar one in the uh, what they call the Scotland, and then also have the Royal College algorithms and various bodies that conduct studies and try to come out with acceptable framework of managing certain type of conditions, certain type of diseases or situations in clinical settings. So where a practitioner has actually followed that, what is the status? Now, the courts treat such protocols as relevant evidence, but not as automatic safe harbors. In other words, not automatic defense to exculpate the defendant from liability. It is relevant evidence in the sense that it is something which will help the court in making the general evaluation as to what happened can be blamed on the defendant healthcare professional or not. But it does not mean that as soon as you say that you followed the protocol, then case closed, you are set free. No, not that. You don't have that automaticity. So let's keep that in mind. So guidelines can work both ways. It can support the claimant, the plaintiff, with respect to whether the professional adhered or complied with the guidelines. So for example, in Ghana, I don't know the current protocol regarding malaria treatment. What is the current protocol? Those of you who are into practice, malaria. Okay. Okay. Good. All right. So that is it. So let's assume that a case has been rushed to a facility and you did the initial, tests or diagnosis, or if you use your visual examination of the patient, and you came to the conclusion that it is a malaria, and you followed what our friend had just told us. And let's assume that the situation of the patient became something else, and you are subsequently sued for clinical negligence. Two things. If you are fortunate and your diagnosis is correct, that it was malaria diagnosis, and oh, please, somebody's mic is on. If you put the mic on, in which then you have crossed the first hurdle. And the second hurdle is if you made the right diagnosis, they do conform strictly to the acceptable protocol for managing malaria. So that is it. But let's assume that your diagnosis was wrong because you probably didn't do the necessary labs and so on. We just took the temperature and said that, well, in Africa, the predominant trouble is malaria. So once the temperature is setting and all that, the person is feverish, you do the malaria regime. And it turns out that it wasn't malaria. Then that becomes something else. So on that score, guidelines, be it the protocols or whatever, when available, can help you, the patient plaintiff, to make your case. And the theory of your case in that respect will be that the healthcare professional or the facility did not conform to the prescribed guidelines. In the same vein, it can also support the defendant healthcare professional or health facility and enable him or it to have some immunity from liability. If the doctor followed the guidelines unless the court is of the view that the particular guideline he followed is maybe outdated or illogical. But if the court does not say that it's an outdated guidelines or a very illogical guidelines, that could, in a way, provide some exculpating defense for the healthcare professional. So just like the Hacks and Co., without withholding penicillin for postpartum staphylococcal infection, which match the prevailing practice, consistent with the prevailing practice. The Court of Appeal found the risks so grave, and for that matter, prophylaxis so simple that no prudent doctor will admit it. Oh, no, I mean, the doctors will tell us prophylaxis, I'm not a clinician, but is a treatment anticipation of maybe something which may occur, and the prophylaxis is supposed to enable you build advanced immunity or something like that. Is that not the case, doctors? Well, thank you very much. Yeah, so the other point, and that is, of course, what he said reinforces what also is a position from the jurisprudence that the courts will not automatically say that because a healthcare professional followed a certain and available guidelines, the guidelines may be, either local, for example, within a particular teaching hospital, let's say that they have their own, local guidelines or something like that for certain things, or it may have been prescribed by a regulator, or it must have been recommended by a regulator or by even association, like the particular healthcare professional association, as it were, that if you have actually complied with that, that will just be deemed as part of the relevant evidence, but it will not necessarily be, if you like, tipping the skills automatically just because you follow that. The court will still have to look at everything. So let's keep that in mind. Again, it is a doctor may depart from a guideline if reasons are cogent and contemporaneously documented. In other words, even if we have available guidelines, available protocol regarding how certain category of conditions are supposed to be handled, but on a particular occasion, a doctor has reasons to believe that the guidelines or the protocols available should not be followed in this particular case I'm handling. Now, in that case, the doctor will have to provide cogent and then, of course, recorded reasons in the clinical notes to justify. And this is a tip for those of you who are, healthcare professionals, and of course, lawyers also who are also solicitors for health facilities. Uh, one of the things which pains me is that after learning so much medical law, instead of making a lot of money from it, I didn't make much money, and then I just came to public service. But I want you to benefit from this so that you make it to protect your health facilities. So let's say you're advising the facility, you are their lawyer. It is prudent for you to remind them that when there are issues, if we have contemporaneous recording, in other words, a recording like something, a report or something which was written at the time of doing particular thing or deciding not to do it, and later on, if there are no incidents and then there's a litigation, such contemporaneous recording will be very useful, evidence in helping you to make one case or the other. So they should pay attention to that. It's very important. It's very important because you don't know when something could go wrong, and you may be required to provide, explanations and so on. Good. So I would like us to look at the this case law a little bit in detail. Penny against no Penny Palmer and Cannon against East Kent Health Authority. Yes, you want to ask a question? Yes. Right. Thank you. You see, these principles we are learning, they are not applied in all or nothing fashion. They are applied in the broader context of how they interact with so many other things. And that is why how some of these principles work out may vary from case to case. So that in one case, where we have evidence that the healthcare professional, for example, has been attending to this particular patient, like the one that you've explained, and he knows the psychology of the patient very well and knows the patient as someone who is extremely, anxious and paranoid, and even seemingly innocuous or benign things, it will provoke significant anxiety or distress, discomfort in that patient. Now, if that is the case, and you have no clinical notes which reflect these observations, for example, uh, and you had, like the illustration that you gave, maybe like 1 out of 1,000 cases in which this particular procedure may result in death. So you decide to keep this, information to yourself without telling the patient, because knowing what I have, narrated about this patient, if he or she is to be told, he or she would even choose not to do the procedure altogether. Now, so you keep it to yourself. You do it, and let's assume that the unfortunate happened, and you find yourself in the arena of accountability for how you handle the case. We can only speculate, but we can make reasonable speculations that if you have, and that is why I said that it varies from, case to case. If the evidence is such that this is a patient that you have been managing, you know the patient's clinical and psychological history and so on, and your clinical notes for a long time, consistent with the psychological assessment that you have made, that this patient cannot take even the most insignificant of uh, possibilities of or probability of something happening. So you're not going to tell the person. I mean, depending upon the facts, you may be able to make a good defense, and especially under the doctrine of a therapeutic privilege. That such non-disclosure was for therapeutic privilege of the patient. But as I said, it's not just enough for you to say this with your mouth. It must be borne out by other corroborating evidence. Very well. Yeah, so let's look at the, yes, yes, please. Right. Yeah, yeah. You see, and that is one of the things. Those who have my book, Development Healthcare Law in Ghana. I think if you go to the last appendix, I have like a interview transcript, which I spoke to some very old, medical legal, experts in the UK, and one of the things which come up is that most of these principles we are learning, they develop from a background of relatively uh, higher developed healthcare system. So that is one thing we should know. And for that matter, the question arises as to should we be applying these things we are learning uh, to our context in the same way from where we are transplanting them from, having regard to the fact that the underlying healthcare system, underlying economic circumstances are not the same. And the doctor-patient relationship and so on and so forth, even health records are not the same. Now, we have the call like the patient passport, NHS. I can just enter my records here and I get access to everything. You go to any practice, they take your date of birth, your name, all your clinical history, everything is there. But we are now trying to build some of these systems. And that is why judges that will handle these type of cases uh, will need to have a certain matured, careful approach as to how some of these principles are actually extrapolated and deployed, as it were. And of course, uh, what the judges will do is also very dependent upon the quality of the lawyers who are presenting the cases. If the lawyers are good, even if the judge does not have the requisite appreciation, he or she can be guided by the work of the lawyers. Yeah, so you are right, but uh, we can also not say that we are going to not do anything until our, our healthcare has developed up to that level. No. Mm. Yeah, so no, Penny, Palmer, and Cannon against Eastern Health Authority. Yes, yeah, yeah, yeah. I've seen him. Yeah. Yeah, as an Nekram, 1975. 70, yeah. Mm. No, I don't. I've seen what he's talking about, but what I rather suggested is that if you look at the just like the UK and the rest, uh, sometimes there are situations in the clinical settings which require immediate, decision, and sometimes there are dilemmas, so we need the court to come in. I just give you, you remember the Ray conjoined twins case? We looked at it last semester. The twins who were conjoined at the pelvis with the one heart and so on and so forth. And if separation surgery had not been done over time, both were going to die. Remember that, and so on. But then, if you do it, also there's a risk that one will have to be killed or one will have to die, and that could give rise to manslaughter. So we are not sure as whether such a procedure should proceed. Situation like that, you may want to get the court to actually come in and give guidance or make some orders. So you need to quickly go to court, but you don't have to follow the usual procedure. So if there can be a very simplified procedure so that as and when there are situations in the clinical setting which require intervention of the court. For example, you are treating Jehovah Witness, blood transfusion and so on, the child, and then the parents are put up a serious position, and then the health facility, you are worried that if this transfusion is not done, the child is going to die. But you have this kind of like serious standoff with the this Jehovah Witness parents. You quickly need to go to court, and then when you go to court, it has to be fast so that it's a matter of hours or sometimes in half a day. You need to get the court. So what I rather encourage is that there should be that simplified procedure which such cases can be routed through without going through the usual issuing a rate and going through pleadings and all that, which can take a while. So if having a simplified procedure, that one I will recommend that, but having a specialized court, I don't think is a good idea, because if you are not careful, you're going to set up specialized courts for so many things in Ghana, and that I don't think is a good idea. If you look at the UK, for example, we don't have a specialized court for medical cases. Almost the High Court, if you take the High Court, which handles family type of cases and all that, they can deal with that. So I think we can also do that. Yeah. So what happened in Penny against East Kent Health Authority? We had three women, Sandra Penny, Helen Palmer, and Leslie Cannon. They brought an action against East Kent Health Authority. Somebody's mic is on. Yeah, so they brought an action against the East Kent Health Authority after each developed invasive cervical adenocarcinoma, despite having received negative cervical smear results, smear tests between 1989 and 1992. So the judge, the trial judge found the East Kent Health Authority liable for negligence in breach of duty, and causation was postponed. So there was an appeal, and the Court of Appeal dismissed the appeal. So that is the basic procedural background. What are the essential facts? So the claimants, they had false smear tests were read by primary screeners in Kent and Canterbury laboratory. So the smears were read as negative. And each claimant later required a radical surgery following invasive adenocarcinoma. You know, like the smear test that is supposed to guard against the cervical cancer and so on. Yeah. So you do it to give indication as whether the patient should be monitored and treated for the risk of cervical cancer. So the smears they did, as I indicated, the primary screeners read them as negative. But later on, it turned out that they needed a radical surgery because of invasive adenocarcinoma. There were independent reviews in 1996 and Wells Inquiry to 1997 reviewed chronic, that is severe understaffing at the hospital, at the facility, poor management, and persistent underreporting of abnormalities in that laboratory at Kent. So during the trial, we had 5 experts, pathologists. They re-examined the slides. So the claimant or the plaintiff brought to Professor Scolton and Crassus. And then the defendant health facility also brought 3 experts, Dr. Hussein, Boone, and Dr. Hughes. Now, on the evidence, although all the experts accepted that screening can never be foolproof or foolproof, meaning that it's not 100% accurate. They disagreed on A, what abnormalities were actually visible in 1989-93 when the screening was done, and B, the standard a reasonably competent screener should have applied. So these are equally good experts, but they have a sharp disagreement on these aspects. So when the matter came before the English Court of Appeal, the issues on appeal were whether the trial court misapplied the professional negligence standard stated in Bolam against the FRIERN Hospital and refined in Bolitho. And 2, whether the trial judge wrongly treated the question of professional opinion as question of primary fact. And at the end, whether the trial judge gave adequate reason, especially on the state of cytology knowledge around 1989, 83, 93. And also there was also a question of the admissibility and weight of a small mock risk screen conducted in one of the experts' laboratory, Professor Crozes. So in terms of like the law, I've just done the brief of the case for you. I'll give you like the full judgment to read. The courts accepted the Bolam test, which is the ordinary scale of competence specialists we'll be talking about, but then emphasized Bolitho, meaning that it must withstand logical scrutiny. So expert opinion is only defensible where it has a logical basis after risks and benefits are weighed. Then all experts agree that a primary screener should mark a smear negative only when satisfied beyond doubt that no clinically significant abnormality is present. So before you mark a smear test, you will return negative. You must have that conviction that there's no clinically significant abnormality present. So the court look at the various the slides from the test, and in terms of like the one Penny, the 1992 one, 4 to 5 groups of abnormal endocervical cells were plainly visible. So a competent screener could not dismiss precancerous change with confidence. So this is the finding the court made. So therefore, on that, the court concluded with that particular patient that failure to classify at least borderline was negligent. So there was a borderline, there was a precancerous change. And again, with respect to the patient canon, the court made the following findings. Obvious glandular abnormalities that the screener should have spotted and referred. So the smear test on this particular patient, the court made those particular factual observations. And in that regard, the court said that there was a negligence with respect to making the record negative. It shouldn't have been negative. It should have been positive. Then, with respect to patient Palmer, her first smear test in the 1989, endo, the court made a finding, endocervical cell groups overlooked altogether. Once seen, they needed referral. So something was seen, but the court said that they have been overlooked instead of making the requisite referral, and that amounted to negligence. Then with respect to the second screen of Dada Palmer, the court made the finding that there were clear abnormalities inconsistent with mere inflammation. And then the expert disagreement itself showed uncertainty. So the fact that the experts were divided meant that there was uncertainty. So the result was that a reasonable screener should have referred. A negative report was negligence. So even if experts are in disagreement, then that even made it more urgent for a reasonable screener who did a smear test to have made a referral. So in the light of this, the English Court of Appeal took the view that the trial judge, Judge Pelpet, was entitled to prefer the claimant's or the plaintiff expert's opinion on what the slides actually showed. Because in the court's view, the primary issue was factual. What could be seen? So if you look at the slide, what could be seen? And in that regard, Bolam did not exclude the screeners once actual abnormalities were identified. So it was not enough to say that this is what these experts think. We have the slides, they've been examined, and these things have been seen. And that is what mattered. Again, if we are going to apply the Bolam or the Bolitho approach, the defense opinion, that is the experts called by the defendants, lack logical force because they accepted the absolute confidence standard, yet excuse a negative report where confidence was impossible. So there was that logical inconsistency. I mean, this one is the law of evidence, so don't worry yourself. So ultimately, the court dismissed the appeal. But the takeaway from the Penny case is that when dispute turns on what is visible on a smear, rather than how to respond, the court must resolve that factual issue first. Competing expert opinion on visibility do not invoke Bolam. So here, you see that the court was trying to say that where we have matters of facts. Is this present or is not present? Once it can be seen and also examined by the court, it's not a question of what a body of other healthcare professionals who have said. So in that case, Bolam is of no help or assistance. And of course, the judgment also reinforces that primary screeners must refer any smear that does not fall within the normal range with absolute confidence. And again, here too, those of you who are into the clinical practice, when it comes to screening, we have a problem. There's something I've observed. You go to various hospitals. In terms of parameters, parameters of or the range, laboratory, parameters, and how to interpret, certain values. In a particular, place, they may have a range. You go to another place, they say that, oh, this is clinically, insignificant. It has to be this, it has to be that. So that is another challenge. That is another challenge. And that is where it becomes relevant that you are following what the best practices are in the field according to the current state of knowledge. Yeah, of course, there have been public inquiries which have actually exposed inefficiency in that particular laboratory. And the decision of the court in this case also prompted tighter quality assurance protocols in the UK, especially when it comes to cytology laboratories, including mandatory double reading and enhanced training to reduce false negatives. And on this note, there's a case, I don't know if I shared it with you, there's a case which came up involving a laboratory in which the results from the laboratory regarding the sickle cell status of the couple became a subject matter of litigation. I'll share that decision with you. The decision came out not too long ago from one of the high courts in Kumasi. So, from all this, the judicial test with respect to relevance of guidelines in trying to determine the standard of care, for that matter, breach of care, is one, currency. How current is the guidelines or the protocol? Was the guideline up to date at the material time? Was it up to date at the material time? And here too, don't let us forget what Lord Denning told us. And we cannot look at the 1949 negligence with the lens of what? 1954, as it were. So we are looking at the guideline, which the edition of the guideline in force at the time that the incident occurred, not at the time that the case is being tried. We don't look at the state of the guidelines at the time that the case is being tried. So let us keep that in mind. Again, the court will also find out what is the rationale. Does it rest on a sound body of peer-reviewed evidence? So guidelines, the protocols, is it consistent with the state of knowledge, especially peer-reviewed literature? Were the patient's circumstances within the intended scope? So the guidelines, the scope of the guidelines must actually be such that the case that we have in mind, we have on hand, actually fit within that particular case. If it does not fit within the scope of that, then the guidelines cannot provide any assistance. And of course, the guidelines will also be subjected to the Bolitho logical scrutiny. Is adherence to the guideline defensible in reason? Or if your compliance with the guidelines will be illogical, then you could be excused from not following it as it were. So let us keep that in mind. If you look at cases of Rainey against University Hospital of North Staffordshire NHS Trust. It provides an example in which the guidelines which we have just run through are actually illustrated or met. So in that case, for example, the NIS, the National Institute of Clinical Excellence, they had what you call the neuropathic pain algorithm, and that was adhered to, and that shielded the rehabilitation team, because the rehabilitation team had actually followed those algorithms prescribed by the NIS. But then the same algorithm failed the currency test in Martin against Leeds Teaching Hospital. In other words, in Martin against Leeds Hospital, the algorithm which had been prescribed by NIS was found to be outmoded regarding the situation there, because they have been superseded by a higher grade evidence review 1 month before the negligence. So let's say a few more things about the Rainey against the University Hospital. So Mrs. Rainey underwent multidisciplinary rehabilitation for chronic neuropathic pain following spinal surgery. So she had to go through a couple of rehabilitation. The Trust Rehabilitation Team, that is the NHS rehabilitation team, adheres strictly to the NIS, that is the National Institute of Clinical Excellence approved neuropathic pain algorithm, which was in force in September 2012, and it prescribed one, the first line therapy with amitriptyline or duloxetine, and then two, dose titration according to a fixed schedule of 4 weeks. 3, assessment points at weeks 2 and 4 to review efficacy and side effects. 4, escalation to second-line agents. Example, pregabalin, only if first line was ineffective or intolerable. And 5, multidisciplinary case review before any departure from the pathway. So these were the recommended protocols. Now, when Mrs. Rainey developed severe dizziness and hyponatremia, the team paused dose escalation, undertook electrolyte monitoring, and convened a specialist pain review. So they brought the specialists, and they had like a review of the case, which happens in the teaching hospital, especially where they have like the team. They have like the team of physicians or healthcare professionals that go around. Now, on the question of negligence, the Court of Appeal held that because no subsequent NIS guidelines, now when I say NIS, you know what I mean, National Institute of Clinical Guidelines, National Institute of Clinical Excellence guidance had been issued. The September 2012 algorithm was the undisputed professional standard. So that met the contemporaneity requirement, meaning that the guideline was what was in force, and what we did actually comply with that. And the algorithm carried a clear risk-benefit rationale mandated by the National Institute for Clinical Excellence. So there was a logical basis and was formally endorsed by the NHS own policies. And the NIS clinical guidelines, that the professional endorsement, was applied to the letter. It was complied with, every bit of it. So every step and every review point was documented. So pay attention, every step and every review point also was documented, so accurate application. So you must document if you are following the guidelines or the protocol which have been approved. As a result, strict adherence to the algorithm insulated the trust from liability for Mrs. Rainey's adverse reaction. So this is a very good authority, which give us an idea that where, and this is very recent, 2022 there, but 2015, where you have strictly followed the guidelines in force, and you have no proper documentation to evidence that if something should go wrong, you could have a good defense, as happened in this particular case. Now, in Martin against Leeds Teaching Hospital, Leeds, Northwest England, Martin presented in May 2022 with persistent neuropathic leg pain. The trust continued using its in-house guideline. Now, I told you that we can have like a local guideline like for a particular facility. So as happened, so the trust continue using its in-house guideline based on July 2021 National Institute of Clinical Excellence neuropathic pain algorithm. Even though in June 2022, NIST had published a grade A evidence update recommending a revised first-line agent, nortriptyline rather than amitriptyline, and narrower titration bands because the trust failed to adopt the updated NIST review. The algorithm was demonstrably out of date by 1 month, so the currency test failed. The new NIST evidence showed better tolerability and fewer interactions with nortriptyline because data absent from the suppressed July 2021 version. And again, there was no professional endorsement because after June 2022, only the updated National Institute of Clinical Excellence guideline commanded the profession's support. The trust local protocol no longer did. And for that matter, there was no argument that you had strictly followed that. So accurate application was irrelevant. If you followed that, what you followed was not current, it's outdated. It does not have the requisite professional endorsement. So if you followed it to the letter, it will still not avail you in terms of defense. So that is the difference. So let's keep that in mind. Yeah, I think we've discussed this now. Yes. Yeah, yes. Right. So if I understood you that if we look at the guidelines, if new ones are issued, there's no explicit statement in the new one that the preceding one has been revoked. Is that the case you want to say? Good, good. Now, where that is the case, then assuming there's a problem, it becomes a matter of interpretation. And then interpretation, we have what they call the doctrine of recency. Unless there are other countervailing, arguments, which will say that the doctrine of recency uh, is not applicable. Otherwise, if it's applicable, then the position will be that so long as the new version is on the same subject matter as the older version, the new version will be deemed or be presumed to have superseded the earlier or the older version. So that will be the approach generally. Yeah. Yes. Right. Good. So, all right. Thank you. So, I think let's go back to the initial principles. We started by making the point that guidelines, protocols, regiments, and what have you, per se, do not provide automatic defense to clinical negligence. Like the mere fact that we have guidelines and you have followed it does not automatically bring the case to an end, that there's no case against you. No. And that is why the position of the law is that the guidelines will be treated as a relevant evidence, which may be admitted when the requisite rules of admissibility are satisfied. And then the court will do its own evaluation and accord appropriate weight to it. And for that matter, where you have no peculiar situations like the one that you have ably articulated, it will be looked at on its own merits, and it will provide the relevant and then the unique context within which the court will make the requisite determination in that particular case. So the point to note is that these things we are learning to large extent are general propositions. And then when it comes to law, and that is the beauty of the common law, and that is why Oliver Wendell Holmes will say that the life of the law has not been logic, but the path of the common law has what? Experience. And the path of the common law being experience means that the common law has the requisite capacity and then the elasticity to accommodate even situations which may be considered outliers or as a novel, as it were. And that is why we have devices or principles like distinguishing an otherwise binding precedent from a current set of facts on hand so that you don't follow it. So it is possible for those, peculiar situations like the one that you are canvassing to be dealt with, uh, on their own terms, on case by case basis. Okay, right. So the takeaway for in terms of practice and litigation for clinicians, the healthcare professionals, as far as these matters are concerned, guidelines, record which guideline they rely on, the version date, and why it applied. And on this, let me make this point. Uh, you know, a lot of us in Ghana, we are very lazy with writing. And I think that healthcare professionals are not excused from that observation too. Some are very good. They want to do all the good care management, but instead of putting down notes, they may not do. And some of them, all that the only time we see them writing is when they're writing a prescription. True or false? Hello? True or false? Yes, thank you. And even, yes, right, right, thank you. Yeah, with respect to uh, the guidelines addressing the problem of the perceived arbitrariness, I mean, you are right, but at the same time too, the guidelines per se are not foolproof in terms of liability for negligence. The guidelines may be useful material in making a claim or putting up a defense, but it's not automatic. That is the first thing we have to note. In any case, the guidelines will not escape what Bolitho is telling us. Bolitho is telling us that even where you have a responsible body of medical opinion, the court must not abdicate its primary obligation of adjudication, it must actually scrutinize, it must examine that body of opinion to find out whether it has internal logical consistency. So that if you have a guidelines, and then the guidelines, the content of the guidelines, for example, are examined, and then it is just supposed against other refined knowledge within the field. And the guidelines, for example, is something containing a lot of questionable ideas and so on. Despite the fact that it's the guidelines, I think that it may suffer credibility deficits, and for that matter, a very little or low weight may be attached to it in terms of evaluation of the evidence. But that notwithstanding, as I said, we still need to follow guidelines if available, except where in extreme case, the guideline may, for example, not have proper logical basis. Then clinicians should document reasoning whenever they depart from written protocol. So when we have a written protocol and you are not going to follow it, you must provide some explanation. Clinicians should college updates and journal alerts, and out-of-date policy offers scant protection, as we know. So if you're a practitioner, and that is why the doctor who just spoke said that some so-called respected and experienced practitioners, clinicians, they don't even have any article to their name and so on and so forth. But the question is, do they stay abreast? Because as you know, one area which is so dynamic is the area of healthcare, because knowledge is not static. There are certain drugs, certain procedures, which were highly regarded as being very effective in managing or curing certain conditions. Over time, new knowledge made possible by scientific research published in peer-reviewed journal will, for example, cast a serious doubt on that and bring up something else, meaning that we may need to move away from that prescription or that procedure. So where you are not reading, you are not staying abreast, you will be a danger to your patients, because patients are supposed to benefit from the updated knowledge in the field, so long as it will help their situation. Yeah, so the courts will continue to adjudicate standard of care, whether technological or documentary, through the twin filters of responsible, body, and logical defensibility, as I have indicated from the Bolitho line. The last, but one sub-theme from our last class is the complex issues in causation, but we have discussed some of these extensively, and because I have like the notes, you read the details of it. Just suffice to remind ourselves that once you have proved that the defendant actually breached the duty of care, you need to establish causation. So traditionally, in terms of factual causation, as we saw last time, from the case of a Barnett against Chelsea Kensington, The question asked is whether the claimant or the plaintiff will have avoided harm but for the breach. Would the plaintiff, that is the patient in this case, would the patient have avoided injury, harm, but for the breach? In other words, if the healthcare professional and vicariously the health facility had not breached the duty of care, and we say that the patient would not have suffered the particular injury, the particular harm is complaining of. So that is what we call like the Bad-Ford test, and it's helpful in establishing factual causation. The injury, was it caused by the breach? Factually. So once factual causation is satisfied, the court must still decide whether the loss, that is whatever injuries, whatever losses which the patient is complaining of, sits within the risks the defendant undertook to guard against. So that is very important. The defendant may be liable in terms of the factual causation, but there are some of the losses which you are looking for compensation. The law may say that no, that cannot be visited upon the defendant because it's too remote, as it were. So what we call the doctrine of the remoteness of damages, as it were. There's a case I'd like you to recite, Australia Asset Management Corporation against Doc Montago Limited. Now, what that was decided has been adapted beautifully in the case of Khan and Miados. In that case, there was a GP who was negligent failure to test a mother for hemophilia A before pregnancy. So the child was born with both hemophilia and autism. Although hemophilia was satisfied the Bad-Ford causation, that is the factual causation, autism did not fall within the scope of the doctor's retainer, which was solely to advise on hemophilia risk. So eventually, when the matter made it to the UK Supreme Court, it held that the GP was liable only for the hemophilia cost. The cost of dealing with the hemophilia, and autism was outside the risk zone, or was not foreseeable, medically foreseeable. Now, similarly, in Chester against the AFSA, that demonstrates an exceptional policy override. What happened in Chester against AFSA? A spine surgeon's failure to warn of 1 to 2% paralysis, that is the risk percentage of paralysis happening following spine surgery was 1 to 2%. Now that failure to warn of the 1 to 2% paralysis risks led the House of Laws to deem the warning itself a protective duty. The House of Law said that the physician, the surgeon, had a duty to warn the patient that there was that 1 to 2% paralysis rate on the neck vertebrae, the spine area. Now, even though the claimant could not prove she would have avoided surgery, the court awarded full damages because informed consent is meant precisely to guard against an unearned injury. In other words, the Bad-Ford causation Because the Bible Causation is saying that the particular harm complained of would it have been avoided if it had not been the fact that you breached your duty of care. Now, that could not be satisfied, strictly speaking, in the case of Chester and Afsa, because during the trial, the woman herself, the patient, admitted that she admitted that she would probably not have avoided the surgery. So she couldn't bring evidence to convince the court that if this 1 to 2% risks have been disclosed to me, I would not have gone ahead to do the surgery. Because of the silence or the failure of the surgeon, and for that matter, the hospital, to make the disclosure, the court said that she was entitled to recover compensation for losses which eventually arose following that procedure. So there's what we call remoteness of damages. The lawyers are familiar with that. And that remoteness of damages or kind of damages rule simply means that where an injury or a harm falls within the scope of the duty of care, which the healthcare professional, the hospital has towards you, liability will be cut off if the damage is too remote. And the damage here, we are talking about the particular losses, the particular troubles, which you have suffered as a result of the breach of the duty of care. If they are considered too remote, not being proximate enough to the breach, the court may refuse it. And how do you determine that? The lawyers among you know the case of the Wagamond, number 1, which remains a benchmark. And it's to the effect that a defendant answers only for harms that were reasonably foreseeable in kind. So harms that were reasonably foreseeable in kind. So when we say reasonably foreseeable in kind, what do we mean? That is to say that the particular losses which the plaintiff is looking for compensation due to the breach of duty of care or the negligence by the defendant, can they be such that they could have been anticipated as likely to occur to the patient if there was a breach of duty of care, if care was not exercised in managing the patient, in diagnosing the patient, as it were. So when it comes to personal injury, the threshold is quite liberal or generous. So, for example, in Page and Smith, it confirms that once physical harm is foreseeable, all psychiatric sequelae are recoverable. In other words, once it was reasonably anticipated or could have been foreseen that a particular physical harm or injury will occur, then all related psychological complaints in relation to that physical injury will be allowed to be recovered in terms of monetary compensation, as it were. On the other hand, when it comes to proprietary or economic losses in medical negligence or medical malpractice suit, is contentious and, for that matter, faces stricter scrutiny. What do you mean by proprietary economic losses? For example, if you say that because there was a breach of duty of care in the surgery which was done to you, you have certain contracts which you were supposed to have gone to China to sign, and that contract will have brought to $2 million and so on. But because of the error in the surgery, it has delayed the period that you have needed to recover from such a surgery according to standard knowledge and practice. So it has affected your ability to travel to China to sign the contract, and then the $2 million that you have made, you have lost that. So that is example of what they call the economic loss. Now, that is really not treated kindly in medical negligence cases. So, for example, in rate against CAMS NHS Trust, where an unexpectedly renewals business loss followed negligent cosmetic surgery, it was ruled too remote. So just like the example that I gave, that the China is the court to say that it's too remote. It's too remote from the the breach of duty of care. In that regard, in their work, Charles Lewis, Clinical Negligence Practical Guide, they make the point that the courts weigh medical foreseeability rather than 10 score outcomes in pure economic case. So when we say 10 score, also known as the eggshell principle. The eggshell principle, the 10 score principle simply says that once it is established that your breach of duty of care actually caused the injury, which the plaintiff or the claimant is complaining of, then all other losses flowing from the injury will actually be borne by you, or where the breach of duty of care by you cause losses or injuries which should not have been occasioned, but for the fact that the defendant the plaintiff has certain underlying or pre-existing conditions which have actually predisposed him or her to be more disposed to getting those extended injuries. You still have to pay. Of course, in criminal law, there's something called take your victim as you find him. So that principle is mutatis mutandis, applicable to the eggshell or the tin score rule. But that is not applicable in terms of economic losses when we are dealing with medical law. And the medical law, the emphasis is more on the medical foreseeability. In other words, that loss, was it reasonably foreseeable? I think we've talked about intervening and superseding causes, so we will not belabor the point. And we are going to discuss a new area, which we call the res ipsa locuto as our substantive topic for today, but because of time, we couldn't do it, so we will look at it at our next class. But just before we go, in terms of causal architecture, that is, having a framework to establish whether the injury the patient is complaining of can actually be linked to the tortfeasor, the defendant, for litigators and also students. So one, you have to establish factual causation, as we were talking about. That is with the BAT4 test or the material contribution test, which we discussed earlier on. And then two, we have to map the scope of duty is this the very risk the advice or the treatment was meant to avert? So it's important to know what advice did the patient come to look for, or what treatment was the patient looking for. And then it brings up this issue, what they call the clinical practitioner, what they call this laparoscopy. Tell us about it so that we'll relate it to this. Yeah, so what is it in practice? Are we together? Anyway, so I think the laparoscopy is what you are doing is an exploratory surgery. You don't have like the particular you know, spot or target, but you have like a general suspicion. So you open up and then you are exploring to try and find out. So where you have seen something and you needed to having, because of how it is, there was a urgent intervention medically. So you try to do something, and in doing it, something goes wrong, and then the patient suffers injury. So in terms of this, is this a very risk that advice with was meant to avert? How will you address that? So the patient probably was complaining of some general stomach upset. We've done all tests. We are not seeing. Okay, so let's take you to the theater. We open you up to explore, and then maybe they come across something which needs to be removed immediately. They're doing the removal, but then there's a problem in doing it. You decide to sue them. Again, the other thing is to check the remoteness we've talked about. Is the damage a foreseeable kind? You must also scan for intervening acts. Did a third party intervene? Novus actus intervenus, as we've discussed. Or did the subsequent medical negligence break the chain of causation? Did the claimant's or the plaintiff's own acts contributed to the negligence, for which reason the compensation recoverable may be reduced by the appropriate percentage, as it were. So let us keep this in mind, and we'll continue at our next class. Yes, somebody hand is up.